Hello everyone, welcome to this month's fun-sized commercial update. As a reminder, if you haven't been to one of these before, in each session I cover one or maybe two cases or other legal updates that have implications for how you draft and negotiate commercial contracts. In each session I spend about 15 minutes talking, so if you've only got 15 minutes then that's you up to date, and then we'll have up to another 15 minutes after that for Q&A if people have questions they want to ask. So as Tom says, please feel free to put questions in the Q&A box while I'm talking, and I will pick those up at the end. I should also say this is going to be the last session of this year because we're then going to be taking a Christmas break. So today I'm going to be talking about incorporation of onerous terms. And this is a case, Blue Sky Solutions and Be Caring Limited. And in this case, this was about a contract for the provision of mobile phone connections. So this was a contract for 800 mobile phones. There was a monthly rental of £9,600 for a minimum of 48 months. So depending on how quick your mental arithmetic is, you may gather that's about £460,000 altogether. So there was a purchase order signed via an e-signing system between Blue Sky and Be Caring. And this had the following wording in it. Now, bearing in mind that the errors in this are not my grammatical errors, but this says all orders and contracts subject to and incorporate our standard terms and conditions. By signing the document, I agree I've logged onto the Blue Sky website and have read, agree and fully understand all the terms and conditions. So that wording was in the purchase order. Note there isn't a direct link to the terms and conditions there, it just directs the user to the Blue Sky website. And so the purchase order was signed by Be Caring. Now, Be Caring, the customer, in actual fact hadn't accessed or read those T's and C's before they were signing. And actually, the person who signed the T's and C's, the CEO of Be Caring, had not actually read them either. And had assumed that, so the business support manager who had originally had all the contact with Blue Sky had assumed that the CEO who was actually signing would read them before signing. And in the CEO's case, she thought she was signing a heads of terms only. So there was some confusion at Be Caring's end as to what they were actually signing, and nobody went away with the terms and conditions. So the contract contained an administration charge of £225 per connection in the event of cancellation before connection. Now, again, depending on your mental arithmetic, that works out at about 40% of the total contract value, or about 18 months worth of charges. So Be Caring cancelled before connection was made, as you might imagine, or we wouldn't have been in court about this. Blue Sky claimed £180,000, which was our £225 times 800 connections, about 40% of the contract value. So Be Caring claimed Blue Sky's terms hadn't been incorporated at all, and if that hadn't worked, they were claiming that that administration charge clause wasn't incorporated because it was unusual or onerous. They then said, well, if that doesn't work, we're also going to claim that the administration charge clause is void as a penalty. When the court looked at this, so starting with that question of incorporation, they did actually conclude that Blue Sky's standard terms and conditions were incorporated. And firstly, they said, well, it's irrelevant that Be Caring's signatory thought they were heads of terms. I think part of this, but there was some confusion around, I think on Be Caring's part, where this document fitted in. They were under the understanding that this was the first stage in putting in place an eventual contract with EE, the actual provider of the mobile connections, whereas actually it was written as a contract between Be Caring and Blue Sky as an independent dealer, for Blue Sky to then go on and procure the contract with EE. So there was this confusion, and I think it's quite interesting that the court said, well, it's irrelevant that you thought they were heads of terms, because I think, there's potentially a question there of intention to contract and all that kind of thing. But I think the court here is sort of taking the stance that you can't just sort of turn up and say that you didn't understand what you were signing and you thought it was something else. Otherwise, you'd be opening the floodgates to all sorts of things. So that bit was irrelevant. And they then went on to look at, there's actually a case from 2015, the Impala warehousing case, that says that a reference to a website in a contractual document may be sufficient to incorporate the standard terms that are on that site. And so that's not necessarily is, but the question really is whether those T's and C's were brought sufficiently to the attention of the other party. So they looked at a few of the sort of details around this, and they said, well, there's no reasonable basis to suggest that Blue Sky had used any different terms and conditions. And Be Caring didn't actually argue that the terms and conditions weren't on the website. So they were there, they were to be found. It was possible to find them from the homepage, and the purchase order plus the terms and conditions was sufficiently certain. The judge said, well, there was enough certainty here to create a contract. And so overall, there was enough to bring the T's and C's to the intention, to the attention of the signing party. So that's that element of it. And I think it seems a little bit borderline, I think, that the T's and C's weren't directly linked to that there's this potential question about intention and all that kind of thing. But that's where we are. So they've got over the first hurdle, terms and conditions are incorporated. So Be Caring's next argument was, well, the administration charge clause wasn't incorporated. And the court agreed with that. They said, actually, this is unduly onerous. And they said, well, the amount of the charge bore no relationship to any likely costs that would be incurred and any loss of profit that would be likely to be suffered. And the net profit on the deal for Blue Sky was actually only in the region of £23,000. And the court also said, well, it's obvious that the costs of the administration of this cancellation would have been minimal, if any, because they hadn't actually done anything yet. The connections hadn't been set up. The other thing that they looked at here was, well, Blue Sky argued that this is standard in the industry. And they said, well, that may be the case, but that doesn't mean that they're not onerous. Effectively, onerous and unusual aren't the same thing. It doesn't have to be an unusual term in order for it to be onerous. So they said, okay, this administration charge clause is unduly onerous. And if that's the case, it needs to be fairly and reasonably drawn to the other party's attention. So this is a case from just 3 years ago, Good Life Foods, which said that a particularly onerous or unusual clause needs to be fairly and reasonably brought to the other party's attention. And the judge said, in this case, that didn't happen. And I mean, the judgment becomes quite entertaining at this point, because he really clearly did not like what Blue Sky had been doing. So he says the terms run in total just over a page of detailed text in closely spaced small type and with no separate clause headings. He says, it's quite clear that the terms are not in any way user-friendly to any reader, let alone a non-legal reader. He said the clause itself was not separately headed and was buried within the body of a section. Just in other things that indicate that the judge wasn't very keen on this, he described the order form itself as positively obfuscated the nature of the contract. He described the terms as voluminous and complex, and said that the offending clause was cunningly concealed in the middle of a dense thicket, which none but the most dedicated could have been expected to discover and extricate. So I think overall, the judge wasn't desperately keen on how Blue Sky were going about business here. And I think that so the judge also drew a distinction between terms in a signed contract, where you've actually got a piece of paper with the terms on it that a person has signed, a piece of paper, an electronic document, whatever, where he said it's reasonably straightforward to understand why a term included in a signed contract will have been adequately brought to the signing party's notice in all but extreme cases. And he contrasted this with a contract that incorporates terms by reference in this way. The terms themselves are not in the document that was signed, but they're just referred to. And he said it's difficult to see why, as a matter of principle, the same extremely restrictive approach should follow, unless the signed contract itself drew attention to the unduly onerous clause. So the implication here was, because this was so onerous, the purchase order should have brought their attention to it. It should have been flagged way before they got to that point in the dense thicket of the terms. They did also refer to the fact that there was no real attempt to comply with the relevant code of practice for the sales and marketing of subscriptions to mobile networks, which requires resellers to take reasonable steps to ensure that a person understands that they're entering into a contract and the key features of that contract. And actually, the judge said this comes very close to a misrepresentation case, in that the offending terms are concealed within detailed T's and C's, making it very hard to see the important from the unimportant. So, as you might expect from all that, obviously the administration charge clause wasn't incorporated, but the judge did go on to look at the third argument that B. Caring had brought up, which was that the administration clause should be void as a penalty. And so the court actually found here, unsurprisingly, that if it had been incorporated, it would have been void as a penalty. It would have been unconscionable to allow the claimant to recover those kind of sums. And as we've already looked at, the sums that they were claiming bore no resemblance to the sort of loss they might have suffered in the case that cancellation happened. And interestingly, the court did say, I bear in mind that the court ought not to be too willing to hold a clause in a commercial contract to be a penalty clause, which I think goes along with the general line of sort of the liquidated damages cases that we've talked about in previous updates, where the courts are pretty reluctant to really interfere with a commercial agreement and to make something not enforceable that the parties have agreed and written down and agreed to. So, what's interesting about this from a drafting point of view? I think it's particularly when we're dealing with standard or unnegotiated terms. So, we're talking about things, we often think about things like UCTA reasonableness. So if you're limiting your liability, you need to be doing so in a reasonable way to be compliant with UCTA. And we often remember our penalties point, penalties for breach of voids, the cold Cavendish and Parking Eye cases, all that kind of thing. But I think it's actually quite easy to forget that even in a B2B contract, there can be issues with the incorporation of onerous and unusual terms if you don't bring them to the attention of the other party, if you're dealing with standard and unnegotiated terms. So I think it's a useful reminder that there's this kind of, you need to be, you'll often see at the beginning of a contract, of a standard terms and conditions, a bit in capital letters and bold saying your attention is drawn to these clauses. And I think it's, even if you're not falling into the bucket of something that might be covered by UCTA and the limitation of liability points, and it might not be a penalty because let's say it's just a payment rather than a consequence of a breach, that kind of thing, there is this potential that something might not be incorporated if you've not brought it to the other party's attention specifically, especially if you're incorporating terms by reference. Then on that point about incorporating terms by reference, as we said from the earlier case, it may be acceptable to link to terms on a website, but you do need to draw them sufficiently to the attention of the other party in order to get them incorporated. And I think in that situation, ideally that's linking directly to the terms. I think what Blue Sky did in this case was a bit on the borderline, just saying you can find the terms on our website. Obviously, this case shows that does sometimes work, but I think there is a, it's just, you don't need to be that vague about it. It's better to just give more certainty, make sure that you're actually going to get your terms incorporated. Why take the risk of just saying they're on our website when you could say, well, they're at this page on our website. And the other thing here, I think is the importance of evidence trails. So there was some debate in this judgment about the lack of concrete evidence as to what was on display on the website at the time. And I suspect that if B. Caring had actually tried to argue that the terms hadn't actually been on the website at the point at which they entered into the contract, they might have had some luck with that, because Blue Sky didn't advance particularly convincing evidence that they were there. There'd been a third-party website developer involved. Blue Sky hadn't obtained any statements from them about what was on the website. And so the only reason this wasn't a problem was because because Be Caring didn't try to make the argument that they weren't there. So I think, again, this all, if you're linking to things and incorporating things by reference, think about how, if you had to prove that later on, that you might actually be able to do so. You know, is it download a time-stamped copy of the terms from a website? There's all those kind of things that you can do, and I think it's worth kind of thinking about that up front when you're doing these things. So that was it for today. As I mentioned at the start, for anyone that is dropping straight off, this will be the last session of the year, as we're going to be taking a Christmas break.